Hello, my name is Laura Thompson. I am a litigation attorney here in the Richmond office with Melone, Hatley, PC. Today, I will be talking about guardian ad litems, or GALs. When parents separate and are going through divorce or child custody disputes, sometimes it's a really emotionally charged time. And so a guardian ad litem will get appointed because each parent might have different thoughts about what is the best interest for the child or for the children. And a guardian ad litem is appointed by the court to look and weigh in on both sides of the issues, but also, talk to that child, witness the child or children, and really help determine a recommendation of what they believe follows the factors of those best interests. And judges appoint the guardian ad litems really to be the eyes and the ears of the court and to serve, as a voice of the children for what likely would be their best interests. And it's an extra layer of protection to really help advocate and protect children and decide what makes sense as far as custody in visitation. And it's not always deciding between one parent or another. Sometimes the best interest is to be with both parents equally. So depending on the jurisdiction, a guardian ad litem might have specialized training like in Virginia, or they're an attorney, or they might be a trained volunteer. Regardless of the background, guardian ad litems are trained and they're there to really advocate for the best interest of the children or child to help determine, who should have custody, whether it's parent or otherwise. Custody disputes can often become contentious. And so judges often rely on guardian ad litems to really come in and identify the child's interests. Guardian ad litems, they can really create an unbiased picture. They can do investigations outside of the courtroom, whether that's going to the child's school or doing home visits. They can assess the situation and assess what's really going on. And that is really helpful to go to the court for them to present, what it is that they see and what they hear from the child. Allegations of abuse and neglect are serious, and courts take them seriously. Guardian ad litems often get appointed to help assess whether those allegations have merit or not, and what would better protect the child or children. They can talk to different witnesses. They can look at, what's going on here and talk to the child and the different parties involved. Sometimes if there's a lack of cooperation between two parents or different parties, and it's really hard for those two parties to talk and figure out what is the best path forward for that child, a guardian ad litem can go between both and between the different parties and identify what is it that that child really needs, whether it's therapy, whether it's a specific school or after school program. Guardian ad litems can talk, assess the situation, and help determine what will benefit that child or children. Sometimes a judge needs that fresh perspective. There might be a lot of back and forth between both of the parents, and that can be loud. And, we have attorneys for parents, there's parents, but you have that those children's interests, and they're not always able to advocate for themselves in court without, having that guardian ad litem or that independent party who can really understand their needs and push through, the contentious nature of a divorce or custody proceeding and really make sure that that child's interests are heard. Courts really want someone who's unbiased. And so guardian ad litems, they come in, fresh perspective, unbiased. Now, sometimes it might seem like, are they just supporting the other side? Are they supporting me? But they're really looking at all issues. And, as they get more information, they aren't going to make up their final judgment, their final mind until after they're in court. They view all of the evidence and testimony, and then they will make that recommendation at the end. And so having that unbiased person really helps identify those best interests. So guardian ad litems might interview the children. And sometimes that might be just having those normal conversations. What is it that you like to do as for activities? And sometimes that is, going a little bit deeper. Sometimes a guardian ad litem might assess who does the child rather spend time with or live with, but there's other factors that go into play. What if a child rather stay with one parent because they're feeding them cake and ice cream for dinner? Is that a good reason? How old is the child? How are they making that decision? And is their choice based on best interests? And, is that child making an informed decision? This is my daughter, and we're going to demonstrate the difference of best interests of the children versus the interests of the children. Hey, Izzy, for tonight, dinner, do you want to eat vegetables or do you want to eat cake and ice cream?
Cake and ice cream.
Why?
It's yummy.
So as you can see, she chose cake and ice cream. So a guardian litem is going to represent the best interests of the children, which might be choosing vegetables. With guardian litems, they have the opportunity and the option to talk to people outside of the child, outside of the parents or the legal guardians. They could talk to doctors, teachers, therapists, neighbors, friends, family friends, extended family, whoever it is, even siblings, they can talk to a whole gamut of people to really determine what are those best interests for the child. A guardian ad litem can look at report cards. They can look at this child's or children's grades. They can look at medical history. They can look at prior court documentation if there's anything about the child welfare. They can look at different documents to help determine, what's really going on. So at the end, a guardian ad litem writes a detailed report. That report is going to say, what is their findings? What do they see based on the evidence that they've, encountered and based on those visits, based on the documents they've read? What do they assess as the child's best interest? And then they present that to the court. If necessary, a guardian ad litem might testify in court. They'll present their findings, they'll verbally give a report, and then oftentimes the judge might ask follow-up questions. And that can be pivotal for when a judge is making that final determination. And ultimately, the judge is making that final decision, but a guardian ad litem's, decision, or really their thoughts and their input can be pivotal with the judge, weighing in. If you have a guardian ad litem that is appointed to your case and you want to hire a lawyer, we're here to help.